Be ready, 10 seconds to go. Start. The Learned Council has further argued that reservation is for participation and representation and cannot be used for poverty alleviation. Reservation in public employment is to reverse discrimination and to equalize representation. Providing government jobs cannot pave a way for economic upliftment, whereas other ways of providing subsidies, etc., is a kind of affirmative action to eliminate poverty. Indeed, poverty alleviation is a goal for the state to strive for as per directive principles of state policy, but reservation is not a way to alleviate poverty, as is evident from the statistics that despite decades of reservation in favor of SCs, STs, and OBCs, they are still poor. Relying on the decision of this court in Minerva Mills Limited, it was stated that alleviation of poverty has to be done without trampling on fundamental rights. Welfare steps can be taken under DPSP, but it cannot be done under Article 15 unless there has been discrimination on the grounds mentioned in Article 15 bracket 1, as otherwise the character of Article 15 is changed and results in abrogating the fundamental rights. As reiterated by this court in Indra Sahone case, Article 16 bracket 4 has to be in consonance with and in furtherance to Article 16 bracket 1. Similarly, Article 16 bracket 6 also has to be in furtherance of equality of opportunity under Article 16 bracket 1. So, if Article 16 bracket 6 is violative of Article 16 bracket 1, it cannot sustain itself in the scheme of the Constitution. Further, relying upon three-judge bench decision of this court in Indra Sahane case, the Learned Council has submitted that by providing reservation to forward class, the identity of backward class is erased and therefore such reservation is illegal, hitting at the roots of the Constitution. Moreover, if the forward class becomes backward, it can come under OBC so as to benefit from reservation. She would reason that the 103rd Constitution Amendment is discriminatory to SCs and STs, as the people falling in EWS are approximately 5%, and for these 5% of people 10% of reservation is provided. The Learned Council would further submit that the amendment in question is arbitrary too, for there is no mechanism or procedure laid down for it, as under Article 340 for identification of genuine EWS. Learned Counsel has based his submission on the ground that the amendment in question. Learned Counsel has submitted that this amendment has created two levels of classification. First, between the classes already covered under Articles 15 bracket 4 and 16 bracket 4 and those who were not, which has resulted in caste based classification. Second, within the forward class between those who were economically weaker and those who were not. Such classification, in his opinion, not only defeats the goal of casteless society as envisaged by the Constituent Assembly, but also attempts to create vertical reservation inside a vertical reservation which is not permitted under the Constitution. The Learned Counsel has further submitted that, as held by this court in Indra Sahone, if castelessness is an ideal of the Constitution, and if this ideal goes into the basic identity of the Constitution, then the constitutional amendment, even if passes the test of equality, violates the basic structure. He has also urged that the condition of adequate representation that controlled Article 16 bracket 4 is intentionally excluded from Articles 15 bracket 6 and 16 bracket 6. Reservation once starts has to end. It cannot be in perpetuity. He has further argued that the amendment in question is violative of the Constitution in as much as grant of reservation to already sufficiently represented classes while excluding those who were inadequately represented offends not only the equality code but also the principle of fraternity as recognized in the preamble to the Constitution. He has supported his contentions while relying upon decisions of this court. Learned Counsel has based his submissions on modern jurisprudence, citing academic scholarship to submit that two things are to be considered while dealing with discrimination law. First, the immutability, and second, it should constitute fundamental choice. Relativity of poverty is opposed to immutability. He has further submitted that the 103rd Amendment, in the context of exclusion, made the forward communities as protected group and the backward class as cognate group, which is impermissible. The amendment in question strips off the right of backward class candidates to contest the seats kept in open category to which they are entitled to. The Learned Counsel has argued that this amendment fails the preference test by giving preferential treatment to forward class and taking it away from backward class who are inadequately represented. He has further submitted that the living tree approach should be applied to interpret the Constitution as per the changing circumstances of the society. Learned Counsel has also argued that fundamental rights are individualistic in nature, and while relying on the decision of this court, he would submit that the individual is the focal point because it is only in the realization of individual rights of the class affected. Stop